Good morning.
Morning, Mr. Glengrove.
Eddie.
Morning.
Hello, Johnny.
It seems that those who are meant to be are here. Can we start?
We are ready to start, Lord.
Yes, we're ready.
Good. Nadia, you can call the matter. Thank you.
Morning, Judge. Calling case number 23795 of 2021 in the application for leave to appeal from Mr. Elias Magashule and Cyril Ramaphosa and others.
Thank you. My lady and my lords, I appear for the applicant in this matter, together with my learned friends, Ms. Silo SC, Ms. Kofa, and Ms. Kumalo.
May it please the court, my learned friends, Mr. Manetti, Mr. Nalane, Ms. Lekokotla, and I appear for the respondents.
Good. Thank you, Counsel. Just before we start, one or two announcements. There was a request from the Johannesburg Bar for approximately 55 pupils to join this hearing, not to assist counsel, but simply to observe the proceedings. And we would be opportune to grant that request. So they probably will join us as the morning progresses. Secondly, an application for leave to appeal is by its nature urgent, and in fixing the date, I hope you're mindful that both Judge Malcheli and I are sitting in two busy urgent courts today. I'm in Pretoria and he's in Johannesburg. Judge Weiner also has matters, and I think we agreed that we'd use the time between 9 a.m. and 12 noon to deal with, and we communicated that to the parties, and we received the concurrence from both parties that that would be in order. And we would appreciate it if we could keep to those timeframes, because we have matters that we would need to hear after that. And on that score, I was just wondering, given that we have 3 hours, whether an hour each and a half an hour for reply would take us to 2.5 hours. Does that sound okay, Mr. Mpofu?
Yes, I tried to call my learned friend, but I think he was busy about half an hour ago. I was going to propose an hour 15 each and then 30 minutes reply, which is not a target. It could be less, but we could try and do it in about 20 minutes.
Okay, good. Well, let's move on that basis. But I think if we take an hour with the outer ceiling of an hour and a quarter, that would be good. You follow me?
Yes, we can try. Yes, with a bonus of a quarter if it's necessary.
If we take an hour and a quarter, then we might push it to an hour and a half. So let's take an hour with an outer limit of an hour and a quarter, and that would still get us there. Okay, good. Good, Mr. Mpofu, we have received the application for leave to appeal as well as the supplementary grounds, and we also have received the heads of argument that were filed yesterday, and we received this morning, I think, a note on oral submissions filed on behalf of the respondents. I'm not sure if you've received that, but that's what I just saw coming in as well. Okay.
Yes.
Okay.
No, thank you. Thank you, Justice Calapan. Yes, we have we sent our heads yesterday, a few hours later than directed, for which we apologize. But we have, yes, we have received. I have received literally a few minutes ago the note from the other side, which is, yeah, I suppose in the circumstances it's okay. So we will then, if we can then start with the just scene setting justices. We're going to divide the argument into three broad areas. The first one is what we call the legal stroke preliminary issues, and that involves the issue of condonation, the strikeout application, and just a quick reference to the supplementary notice. In other words, the application to lead new evidence, which is obviously not before you. That's why we're going to refer to it very fleetingly. And so that's, let's call that one broad section. Then there is what we call the merits, and in our heads that's the grounds from A6 to A10. There are 6 grounds, but we can condense it to 5. A5 and A6 will combine as one submission. That's the issue of the precautionary stroke punitive and so on. And then we'll deal with the other 4 topics as they appear in the head. And then we have isolated, for reasons which will become clear from the so-called preliminary legal issues, the issue of judicial bias as a standalone broad issue that we wish to address. So if I may then quickly start with what we call the legal stroke preliminary issues. I will not rehash. We gave quite relatively detailed notice and very detailed heads as well on each topic, and we assume, knowing that there was shortness of time, that the court has had time to read our heads at least, even if not in detail. We then would like to start with the issue of condonation. There we simply say that the court really made a gross misdirection in firstly granting the condonation asked for by the first respondent, but also in a way indirectly granting the condonation not asked for by the first and second respondent. And the reason why the first and second respondent did not even ask for condonation was based on the flimsy excuse that there was some assumption that there was an agreement to file the heads on the 25th. There's no basis for that assumption at all. Despite what the court said, the issue of the case management meeting, judicial case management meeting before Sutherland DJP is completely irrelevant to what we're discussing under that topic. Because that's...
Sorry, Mr. Mpofu, what about the 2 letters written by the respondent's attorney suggesting dates and no response coming to that?
Well, let's assume that is so, my lady. So,
well, it is so.
Well, can I answer the question? Presumably, I'm making it easy because we don't have time. I'm saying yes. Just assume this so I'm not arguing with you. Yeah. I'm saying let's assume for now that there were those letters and they were not responded to. Then the only thing you can deduct from that is some assumption that there is consent. So-called silence means consent. Well, that argument is completely unsustainable on the facts of this case. It's convenient if we just want to assume some agreement. But that assumption of an agreement would have been completely dispelled when the other side received the replying affidavit, right? Because the replying affidavit made it clear that there was no such agreement, okay? So even if someone had somehow thought that there was an agreement, then under oath, in the replying affidavit, the applicant made it clear that there was no such agreement. Once it became clear then at the very least, the other side would have said, oops, we thought there was an agreement, like Justice Weiner, but now we are aware that there was no such agreement. Therefore, we'll either do a supplementary affidavit to ask for condonation, or at the very least, we'll address this in our heads and say, no, we thought there was an agreement. There's no such thing, nothing like that. All that comes from the bar at the day 2 or day 1 of the agreement, and the court accepts it as if it is indeed so. There's no, I mean, that's not even a blasé attitude. that's what I call a complete arrogance on the part of the respondent, because they could have said, okay, just a one-liner. No, we are sorry. We thought we had an agreement. We see now that you are reneging from the agreement, or whatever they wanted to allege. But they didn't say such thing. So that argument, with respect, is completely has short legs, and it's unsustainable on the facts of this case. I'm told that in this letter, they say we are progressing nonetheless with the preparations and consultations with our clients and counsel, and hope to revert shortly on when we estimate to be filing our answering affidavit. That's all. They never reverted, and then so that anyway, there was no agreement. That's the answer really. So absent an agreement between the parties and having with the applicant having explicitly and expressly indicated that there was no such meeting of the minds. An agreement, as we know, it is consensus ad idem, contract law 1. So if there was no meeting of the minds, there was no meeting of the minds, so there was no agreement. So this agreement that is now presumed after the fact because of submissions from the bar was completely non-existent. And the point we were making is exactly that. It was not so much, it was not asking for condemnation and not even asking for it when it was clear that there was no agreement. Or let's assume the applicant was lying and saying there was no agreement when there was an agreement. But that itself needed to be addressed. You can't just come to court as if nothing has happened. Anyway, so that's what our courts have said repeatedly, that parties must not be blasé about condemnation. It's not just for the mere taking. It's a serious indulgence, and then the court also says that there was no objection. Let's assume there was no objection. Remember what the effect of a Republican's case is that the date that is nominated by the applicant is for shorthand assumed to be the date in the rules. So it becomes a rule, as it were. And that's what happens to all of us. If you exceed, forget about agency, if you exceed the dates in the rules, if it says 10 days and you do it on day 12, you ask for condonation. You don't say, well, there was no objection. Or even if there was an agreement for that matter, it doesn't matter. The court may still not condone exceeding the time limit prescribed in the. So the agreement is not an answer at all on either ground. Anyway, so the whole point of granting condonation and then not even showing any displeasure by a court order is something that is a gross misdirection in the light of the authorities, including constitutional court authorities, on how courts should approach the question of condemnation. Then we'll move to the strike out.
Mr. Mpofu, before you move off the condonation issue, we know there are basically two essential principles. You've already alluded to one, being that the extension of the time or allowing a party to proceed when you haven't complied with time frames, it's an indulgence from the court. Secondly, the Constitutional Court and the cases that you've referred to has indicated that condonation should be granted in the interest of justice.
Correct.
Now, I'm just wondering whether if the court has, and the third element to that is the fact that the court has got the inherent power to control its own proceedings.
Yes.
If one looks at this matter, and the point that my sister made earlier, that there was case management, and this was an urgent matter. Are you saying in the totality of that, the court could not indulge?
No. Firstly, there are two answers to that, Justice Mulahle. The court cannot do that ex post facto today. If the court relied on those grounds, it would have said so in its judgment. We are now at the level of application for leave to appeal, so it's too late to find new justifications for the judgment. So the court put its bed, as it were, made its bed, and that bed was not based on what you are saying. That bed was based on the fact that there was no need to ask for condonation, which is an extreme thing, because you are quite right. The courts say that there must be a satisfactory explanation. Here we're dealing with the most extreme example of that, where there's no explanation, satisfactory or otherwise. So I'm afraid it's too late for that. The court could do what you are saying, but it did not do it. It chose to base its judgment on the fact that there is no need for condonation when there was a need for condonation. That's the misdirection. So it's not, it can be cured in this court. It will be cured in the appeal court. That's the point we're making. So that problem you are functus officio now. It can be cured.
You've made the point, Mr. Mpofu. Let's move on.
Thank you. Thank you. Now moving on to the issue of the strikeout application. There, really, we don't. Firstly, we don't understand the some of the such. Let's start with the easiest one, the duplicated documents. Well, in our understanding, even the other side had almost considered that those portions had to be struck out, because this suggestion that a document is relevant. In other words, you can put a document 100 times, you can attach the same letter 100 times, and if letter number 1 is relevant, then the other 99 are also relevant. Surely that can be what Rule 615 contemplated. The point of the matter is that once it is possible, logically and legally, that one document could be relevant, but its duplication numerous times, let's assume it was a 100-page document, and then you put it another 10 times, so you have 1,000 pages, and then you say, no, well, if the first 100 was relevant, the other 900 are also relevant. Surely that you just have to make a statement like that to reject it. So those documents were clearly irrelevant, at least the duplicated ones, and they should have been struck out with costs. Why is that so? We gave the reasons. Firstly, because it was an inconvenience for us to have a team here of 4 counsel. So each person has to make an extra copy of the same thing. And secondly, this matter, I think it could be predicted, is a matter that's going to go on appeal, maybe once, maybe twice. And then these duplications must be carried through. So when we say the inconvenience of the court, we don't mean this court only. We mean the court in general terms should be inconvenienced by this mere duplication. So one would have thought that was the most obvious, but the court was not prepared to grant us even the most obvious relief where we are aggrieved. And therefore, we're almost 100% sure that another court not would, but will come to a different conclusion on the relevance of the duplications and award as cost. As far as the other documents are concerned, how this court could say that the attachment of a judgment, a long judgment, which is a high court judgment, which is a subject of an appeal, which anybody can see from the law reports, is relevant, beats me, quite frankly. So why do you do that? Who does that? Attach a judgment, make a copy of a judgment and attach it, not even to heads of argument, but to an affidavit. And then it's found that that's fine. Put aside the fact that that case actually has absolutely nothing to do with any issue before you, literally. That case, even if there was such a practice of attaching reams and reams of court judgments, that particular case has got absolute, despite what the court says in its judgment, that court has got nothing to do with what we are dealing with. That case deals with whether the public protector has jurisdiction to inquire into ANC activities, basically. and it finds that she doesn't. But so what? What has that got to do here? Here we are in the ANC in this case. So that case is completely irrelevant. Whether Mr. Ramaphosa admits, by the way, that he personally not only used money to advance political objectives and to buy a conference, but that he contributed himself. Forget the other sealed documents about who contributed. He says he himself, Mr. Ramaphosa, paid money to buy the conference. So what more do you need for the purposes of this case, not that case that happened in the Concord or whatever? Thirdly, the judgment that is attached was at the time, it is common cause in front of the Constitutional Court. So even if it was of any tangential relevance, it no longer was, the vogue thing in town. So in what world could that ever be allowed? One, put a judgment, any judgment. Two, judgment that is irrelevant. Three, a judgment that is on appeal. And then that's fine, you can do that. So the pupils who are watching now, the 55 pupils, must now assume that you can do things like that. You can just put, can attach judgments into an affidavit. No, you can't. I think we must tell them now, or otherwise we'll have 55 other aberrations coming up. So the strikeout on that basis is also, and then thirdly, I don't even have to say this, attaching the public protector's report. I've already explained how irrelevant the judgment is, let alone the public protector's report. I mean, you could even have referred to it, at least, irrelevant as it is, but to actually attach it. So really, the application to strike out should have been granted, and with punitive costs, actually. There are cases, many cases, which show in why punitive costs should be. But we can't have a situation where 3 senior counsels attach a judgment to an affidavit, and that is endorsed as okay. Now, the last under this heading is this issue of the, I said I'll refer to it very briefly, of the further evidence. And I want to make it clear, that application is not before this court. We simply wanted, in the context of an application for leave to appeal, we, if you like, wanted to give this court what one might call a judicial peek into what we will do in the appeal court, which is to apply to introduce new evidence. And that new evidence is materially important in the context of this judgment. Why? Because this judgment is really premised on one fundamental philosophical foundation, which is the acceptance of the theory, to be generous, that the ANC was motivated by some anti-corruption crusade and evangelism, which is completely not the case. On our version, the suspension was motivated by nothing other than factionalism, and the application of the step-aside side rule is done in a factional way. Hence, the two issues that we wish to raise in the Supreme Court of Appeal, both of which happened after this case. So we will have a ground for introducing the new evidence, because usually the question is why.
Sorry to interrupt you, Mr. Mpofu. Could I just ask, in applying our minds to the merits of the application for leave to appeal, and given that the application to introduce new evidence will only arise if and when the matter serves before a higher court, are we to exclude from our consideration in this matter the issue and the content of what that new evidence might be? Because ultimately that doesn't and should not impact on whether leave is granted or not, correctly, sir?
No, Justice Kalapan, I take that point. I take it wholeheartedly. And that's why I started with an apology, if you like, or a qualification. Yeah. The only point we make is simply, and we can't take it higher than this, because quite frankly, you don't even have that evidence in front of you, except to the extent that we have described it. So, and we've described it in two ways. We simply said the first evidence that we wish to introduce in the appeal court will be the evidence that Mr. Ramaphosa's testimony before the Zondo Commission. We will introduce it in the SCA if we get that far. For the sole purposes of demonstrating that he himself is guilty of corruption, because according to that evidence, he said that he was aware of corruption for 4 years and he kept quiet.
But with respect, Mr. Mpofu, are we not, to the extent that we're agreeing that that is not part of what we need to look at, is there not the risk that what we do now is you give us a peek into that evidence, which is not relevant to our determination? And then it becomes part of this hearing. The respondents might feel they have to respond to it. So are we not in danger of actually traversing an area of a possible scenario in an appeal court that really is not relevant to our work today? I just raise that because I don't want to...
Yes, no, I understand. And as I said, I'm not going to spend a lot, at least I was not intending to spend a lot of time on this.
Yes.
The only point I wish to make is that both the evidence of the Zondo Commission confession to corruption and the reshuffle where people who are candidates for step aside have been promoted by Mr. Ramaphosa. All that is relevant only to this extent in an application of this nature. That, and I accept that it's not a typical argument. You have to postulate that and that's why it weakens it, because it is an if the evidence is accepted by the appeal court, at least you can postulate that it will be of decisive moment. That's as far as I can take it. I can't take it further than that.
Okay.
In other words, let's assume I'm making an extreme example. You find somebody guilty of murder, and then later I come and I say I want to leave to appeal because they've now found the real killer. Of course, that was not before you at the time, but it's something that must weigh in your head, that there is a possibility that the next court might take into account the fact that subsequent to your judgment, which cannot be faulted because you didn't have that argument, subsequent to that judgment, something drastic or dramatic, maybe it's not as dramatic as we think, but the other court might think it is. But to reshuffle people who have been charged with corruption and promote them must have something to do with whether the step aside is being implemented factionally or it is being implemented, as you say, for holy and evangelistical purposes.
Okay, point taken.
Thank you. So then we move to what I call I think I'm just looking at the clock. I'll move very quickly to the merits so that we can deal with judicial bias last. Well, let me just say this. There are countless reasons why this court, given the test, should be convinced that another court would come to a different conclusion. We are very mindful of the so-called heightened test, but in our respectful submission, we even exceed the heightened test. And as I say, on some of the grounds, I will go as far as to say another court will come to a different conclusion. But I'm happy to sit it at wood. Let me just take one issue, what I call the combination of our grounds A5 and A6. This court, one of the basic premises on the merits was this recategorization of a suspension, of this suspension in particular. On the one hand, this court says this suspension is not a part of the disciplinary matrix, let's call it, of the ANC. Well, that surely another court would come to a different conclusion, or at least there's a reasonable possibility that another court might just find the fact that 2570 is, as it is named under Rule 25, might find that that means the Rule 25 that has a big heading that says disciplinary procedures. So there might be a court that just has this idea that therefore it is part of the disciplinary procedures. So that's the one thing. It's not beyond the realms of possibility that another court might say, if a heading says we are now dealing with vegetables, then what is down there will be a vegetable. So that's just a basic principle of law. The second issue is that is then, and that's why we combine A5 and A6, because you will see that there's a legal illogicality. You cannot say on the one hand that this is not disciplinary, and then when it is, just for the purposes of excluding Appendix 3, because we know Appendix 3 applies to this disciplinary. So in order to get rid of Appendix 3, we say, no, this is not disciplinary, so that we don't have to have audi, presumption of innocence, the right to appeal, and all those things. Fine. Let's say that is allowed. Then, in the same breath, you then say, no, this is a precautionary suspension. Well, you can't do that. Because what is a precautionary suspension? Precautionary suspension is a suspension that is imposed pending disciplinary proceedings. So it can be not precautionary proceedings, but not disciplinary for the purposes of, it's just unsustainable. Because the case that this court relied on of John versus Rees actually shows this. And by the way, sorry, this case called John Grogan, Workplace Law. I'll just read one sentence at page 160. I don't know if this is the latest edition. It's page 160 of the 2017.
Sorry, Mr. Mpofu.
Suspension may be.
Sorry, Mr. Mpofu. I don't know if it's only
I'm sorry,
me.
Justice.
I don't know if it's only me, but
Justice Wayne has just frozen a little bit.
Oh, you froze. Okay. Can you hear me now?
She's mute.
I'm not on mute. Mute.
I can't hear you, Justice. I think either you're on my screen, you're mute. I think you're muted.
Okay. Can everybody else hear me?
Yes,
Yes.
I
think
can
it's
hear
your
you.
side,
It's
Mr. Mpofu, because I couldn't hear you just now. You could freeze.
Oh, yes. Okay. Yes. No, then there was something wrong because I was also not on mute. It means there was something. Yes, I'm sorry, Justice. Yes, I'm listening now. I can hear you.
I think it's something with you.
Oh, can't.
Mr. Mpofu, it seems like the problem is on your side. We can hear each other very well. And I think what Judge Wayner was saying that you cut when you started making reference, I think you're referring to a book. You said it's 2017. That's what we could hear.
Yes. Mr. Mpofu, we may have lost Mr. Mpofu. Let's see. Is there anyone from the applicant's team that can give us an indication whether
He seems to be coming back.
Oh, yes, you're back now. Okay. Mr. Mpofu, you're on mute now. Okay.
Yes, I think there was a technical problem. I couldn't hear Justice Winner, and I think she couldn't hear me too. Yeah.
Okay.
All I was saying to you was that I couldn't hear you.
Okay.
Oh, okay.
So, Mr. Mpofu, you were busy making a reference to Grogan workplace law. Okay.
Grogan, yes. Yes. I just wanted to read one sentence of how he described a suspension. He says, a suspension may be of two kinds. It may be imposed either as a precautionary measure pending disciplinary action or as a form of a disciplinary penalty. And that's what shows the illogicality of our ground A5. If you look at our ground A5 and A6 together, and that's why I said we'll combine them. Can you hear me now, Justice Sullivan?
Mr. Mpofu, it's a bit of stop-start. Let's see. We missed a couple of words there. I don't think it was all that material, but let's carry on. And if we run into difficulties, we'll indicate to you immediately. Okay.
Yes. Yes. Thank you. Okay. Let me put it in shorthand. The point I'm making is simply that the reasoning of the court in what we call ground A5 and the reasoning of the court in ground A6 is self-contradictory and mutually destructive. Because and to crown it all, that is confirmed by the case of John versus Rees, on which this court relied in its support for the Long case. By the time you introduce Long, then the confusion gets worse. So let's not go there, because this court tried to reconcile Long with John versus Rees, which is completely out of place, because John versus Rees specifically says that a suspension must be viewed pro tanto as an expulsion, because both of them have adverse effects on a person's membership or office. So in this case, let's talk more office.
Can I just ask you, Mr. Mpofu, you said that you were in referring to Grogan, that, or even before that, that a precautionary suspension is pending a disciplinary process.
Yes.
But in this particular case, the precautionary suspension was pending the criminal proceedings, as far as I understood it, until his name was cleared, the person's name was cleared, if they had already been charged. So was there any disciplinary proceeding pending, or isn't it really the criminal charge that's pending?
No, it doesn't. No, I'm sorry. That cannot work like that. You can't suspend an employee pending some other external process somewhere in the world. What you do, a precautionary suspension, by definition, is to ensure, for example, that the person does not interfere with an investigation, let's say in the workplace, right? So you can't say, no, I'm suspending you in the workplace so that you don't interfere with the investigation of the police, for example, out there.
I don't think it has anything to do with interfering in the work of the police. I think it has to do with while you are under, while you've been indicted, pending that case, you are suspended. So it's not really pending point.
Justice Weiner, there is another case. I think I left it upstairs. No, a precautionary suspension is by definition, right? A suspension like the one in Long, where the disciplinary process is going to take place in the workplace. That's the point I'm making. I'm making a simple point. Let's forget for now about the what's happening in the High Court. If you are right, Justice Weiner, then the situation is even worse than what we imagine, because there can be no doubt that the process that is happening in the High Court is punitive, and yet your judgment says this is not connected to a punitive consequence. So that answer would make things worse for the respondents, I'm afraid, because it demonstrates exactly the point I'm making. If it was pending a disciplinary action where the worst thing that could happen to you is that you get fired, let alone imagine now if it's pending an action where you can go to jail for 50 years. So how can that be a better situation than where you could just be fired or have a warning? Surely that makes it 100 times worse, what you're saying, and makes it clear that it's connected to punitive consequences, unlike what this court found. So even if that was indeed so, it would be, it would simply make the issues worse. But the point of the matter, let's not speculate. Let's go to paragraph 113 of the judgment, and where this court refers to Lewis versus Heffer and others, and John Rees. It explains that it says very often irregularities are disclosed. Oh, I'm sorry, no, the second sentence. So those words apply no doubt to suspensions which are inflicted by way of punishment. And that, we know that's not what we're dealing with here. As for instance, where a member of the bar is suspended from practice from 6 months. Well, on the postulation of Justice Weiner, actually, we are dealing with this, because forget about practice from 6 months, you can be in jail for 10 years. Yeah. Or when a solicitor is suspended from practice. Then but they do not apply to suspensions which are made as a holding operation pending inquiries, right? So the very case that this court relied on makes it clear that those are cases, it applies, or rather the exemption applies to cases where there's a pending inquiry. All I'm pointing out is that another court might find that because there's no pending inquiry here, that reliance was a gross misdirection. That's the only issue I'm making. Then, if we then move to, and therefore, to try and reconcile that court, that case, which actually makes a bigger statement than Long, with Long, is unsustainable. The first sentence of the John Rees case says that the suspension is merely expulsion pro tanto. In other words, a suspension must be viewed as an expulsion, and that, of course, again has punitive consequences. So, I'm sorry, the inconsistency. If we introduce the Long issue, then even it becomes a triple complex. Irresolvable logical issue. Right, then we go to the issue of the jurisdictional requirements. I think that is, for me, probably on the merits, the worst of these grounds. Because here, it's a very simple, let's assume for a minute that 2570 is constitutional and so on and so on. The simple issue we were raising here is that, and it has two legal principles embedded in it, is that the requirements, the bare requirements, and that I hope the pupils are listening, because when you analyze any offense, the first thing you do is to look for the elements. What are the elements of 2570? The NWC must make a decision, 1, tick. 2, that decision, and then the Secretary General must apply his mind and exercise a discretion as to whether it is in the interest of the ANC. 3 requirements. Let's just stick with those 3. Here, have evidence of the NWC giving the necessary instruction to the SG. And I'm not now arguing the issue of authority. Let's assume it's the DSG for the purposes of this. Then the DSG herself must exercise the discretion. She didn't, right? It says in her own letter that the discretion was exercised by the NWC. Ironically, this court relied on the case of Makawa. The case of Makawa versus Mahuma makes that point beautifully because it says that if a decision is taken by the paragraph 8, members may be expelled only by a structure of the voluntary association entrusted with the power of expulsion expressly or by clear and unambiguous implication. A purported expulsion, and can read suspension here, by a structure other than one in which this power is vested in terms of the constitution of that voluntary association will be ultra vires and unlawful. Can't be clearer than that. And then they rely on Yiba's case, which we also relied on, and then they also relied on Losa for that basic and tight proposition, really. So there is no way in which the assuming 2570 is lawful, is constitutional, that its requirements were met on these facts. Just no way. Put on top of that the fact that the DSG was not authorized in any event, to the extent that she belatedly in the affidavit says, I also was of the same view as the NWC. Well, that has two problems. One, she's not authorized. Secondly, she would have abdicated part of the power, at least on her own confession, to an unauthorized structure called the NWC, because she would say she was equally, quote unquote. So 50% was taken by her, the other 50% by the unauthorized body. Well, 50% of unauthorized ultra-virus is ultra-virus. So there's no basis upon which the suspension can be justified on the application of 2570 at all. So that's the second ground. The third ground, or rather the third broad ground, is the misapplication, with the greatest respect, of Ramakat. And that's a serious matter because the Ramakat decision has been there for about 10 years. I can attest, because I was in that case, that since that time, there has fortunately been some stability in this area of law, in the sense that Ramakat really has become the Bible, because it defines the law of political parties. And as we say in the heads, now we're entering election season. There's going to be Ramakat in every province, because people are going to be either taken off the lists and all that kind of thing. And Ramakat, this court, with the greatest respect, misapplied Ramakat and really stuck with a throwaway comment, if I may like, throwaway comment that is made at paragraph 73 of Ramakat. That throwaway comment is something we all agree with, which says that a voluntary association must run its own affairs. I mean, who would dispute that? That's not the point. The point is that Ramakat says the real ratio of Ramakat is the following. Because political parties are so important, they are not like any other voluntary association, number one. Number two, because the Section 19 operates in the public space, every citizen is given a right to participate in a political party of his choice or her choice, full stop. Three, that participation, if it is curtailed, limited in constitutional language, then that's fine, you can limit it like any other right, whether it's the right to dignity or whatever. But then the consequence of limiting a right enshrined in the Bill of Rights is that it will attract a Section 36 inquiry. That's it. So that's Ramakat. the fact that, of course, in the internal workings of anything, whether it's a soccer club or whatever, is within its realm. Is neither here nor there. Here we're saying the letter of suspension is very clear. It uses the word participate. It says you may not participate in these activities. So therefore, there is a limitation of the participation rights or in the party of your choice. That's common cause almost. If it's disputed, I'll be surprised. So once that limitation then happens, the only inquiry is that it may or may not be justified, like all other limitations. But this here, nothing was done of the sort. This court did not, because the court did not pass the first hurdle of recognizing that there's a limitation of the participation rights. It therefore could not have done a Section 36 inquiry, because the first mistake leads to the second mistake, so to speak. You can't do, until you acknowledge that participation rights have been limited, you will not do a Section 36 inquiry. And therefore, you are not applying Ramakat. You might be applying something else, but it's definitely not Ramakat. And that is binding authority on you, on this court. It's authority of the Constitutional Court, and it has been confirmed in Ramakatsa 2 by the SCA. So this court really had no power to apply Ramakatsa in this fashion of just clinging to the fact that what does it say in Section 73, paragraph 73, that a court doesn't interfere on how, that's the word, how, on how a party runs its business. We're not there. We're not talking about how a party runs its business or how you participate. We're here on whether your participation has been infringed. And we know that it has. There are two things, how and whether are worlds apart in this connection. Then there's the issue of the narrowing. I don't even have to spend time there because we've gone through this. Well, all we are saying is that the mere fact that the category of offenders called those who buy conferences is now excluded from the so-called categories is itself a narrowing or an amendment, whatever you call it. And that the NEC does not have that jurisdiction. Again, it's ultra-virus. The NEC has no jurisdiction to narrow, amend, vary, whatever you call it, a national conference resolution. Simple. That's just how the ANC works, I'm afraid. So if that is so, then the amendment is by itself unlawful. Forget the morality of whether it's done for factional purposes or whatever. Just at a technical level, it's not allowed to be done. And by the way, another interesting, if there's a fourth dimension contradiction to the issue that this is not a disciplinary issue. If you go to the guidelines, I think it's paragraph 3.3. It says that of the guidelines, it says that a person will be suspended pending disciplinary measures, which goes back to the debate that we had. So even the ANC doesn't say what the court says, which is that this is a precautionary suspension. It sees that, or at least let me put it this way, the ANC recognizes that a real precautionary suspension is the one pending a disciplinary action, which this is not. I'll just try and get 3.3 of the guidelines. But anyway, I don't want to go back to that. Then the last point under the merits is what we call the unsolicited validation of the, or invalidation rather, of the Ramaphosa suspension. This court, either with the greatest respect, maybe it's our fault, maybe we didn't explain the nature of the relief we sought in 2.4. In 2.4, we were specifically, and I was at pains to point this out, we were not saying that this court must find that the suspension of Mr. Ramaphosa is valid or invalid. We were simply saying the principle is that that suspension cannot be invalidated by Mr. Ramaphosa himself at a press conference. It must be invalidated either by a court or any of the ANC's disciplinary structures or whatever. And you can't just wake up and say, it's like somebody gets fired at work and they don't give you a hearing, they don't do anything, they just say you must leave right now. You can't say, no, I'm coming to work tomorrow because this is clearly so unlawful. No, it doesn't work like that. You go to court or to the CCMA or whatever, and then you show that that suspension was, or rather that expulsion or dismissal was wrong. That's how it works. You don't just wake up and say, look at it, look at them driving me out of the gate without a hearing. Then, therefore, I'm just going to rock up and invalidate it myself. It doesn't work like that. But the court not only did it not do that which it was supposed to do, it went to another area of saying, no, that suspension was invalid. Nobody asked it to do so. There's no counter application by anyone to say that it should be so done. And the court on its own just goes on and says, no, it was fine. And what is worse, the court then says what is also fine is the fact that Mr. Magashule, in his absence, having been unlawfully evicted, was found guilty and sentenced to an apology. And the court says it's axiomatic that if the Ramaphosa suspension was invalid, therefore you can be bundled out and be sentenced in absentia and be told that you have breached the rules and you must apologize and be sentenced to an apology in your absence. What has that got to do with whether the Mr. Ramaphosa's suspension was valid or not? Let's assume it was invalid. Can that then justify somebody being somebody who actually attended the meeting? You could have even said, okay, before we chase you out, there's this small matter of your letter. What have you got to say? No, you start by chasing them out. Then when they are gone, you say, we've found you guilty. We have not only have we convicted you, we've also sentenced you. And the court says that's fine, axiomatically. Well, yes. Yes, the point I wanted to refer to, I'm sorry, to jump back, it's 001-86 of the, where I want to refer to the guidelines. It says, conduct leading to a member office bearer being indicted to appear before a court of law, that is like Mr. Magashule, especially that of corruption, or any other serious offense could also constitute act of misconduct in terms of 2517 on the ANC Constitution, for which disciplinary proceedings could be invoked and instituted against such a member, office bearer, or public representative. So that's a cross-reference to 25.17.4 and 25, I think, 0.68. I'm doing this from memory, which are the rules that allow for temporary suspension on these grounds as well. So that's on any one of those 5 grounds, the reasonable prospects, particularly the stare decisis and the contradiction on the issue of punitive or pending disciplinary processes and so on. So then now we come to the issue of judicial bias. We have said that this court was biased or perceived to be biased, and because of some of the issues that I've raised and just a reading of the judgment, it would seem that the court, by any means, including condonation and strikeout application, duplications which are condoned, was just determined to find in favor of Mr. Ramaphosa and other respondents, no matter what. Whether
sorry, Mr. Mpofu, could I just understand the argument?
Yes.
Is the argument based on the totality and the consistency with which the court found against Mr. Magashule, taken collectively, sustains a conclusion of bias or a perception of bias? Is that the tenor of the argument?
No, that it is part of the tenor of the argument, but it's not everything. And that's and you are right, Justice Colopin. That is the first proposition I was making. I was making about the overall one. That's why I'm talking about condonation, strikeout applications, like everything just had to be found against Mr. Magashule, even when it was blatantly. I mean, a small thing like not asking for condonation. A court should just, quite frankly, reprimand. Even if it's going to find in their favor, any party that treats a court in such a blasé fashion and not even raise the matter, even in its heads of argument. But no, and as I say, a court cannot condone I've never seen it in my life, to be honest, where a full judgment is attached into an affidavit. I've never seen it, literally. Maybe it's me. So to condone things like that was just to say that there's nothing. Even if Mr. Magashule were to say today is Wednesday, the court would have found that no, he is wrong. What day is it? Tuesday, whatever. So
it would have been wrong.
Yes, in that case, the court would have, yeah. But if he said it was Tuesday, the court would have said it's wrong again. So that's the point I'm making here. So
okay.
No, you go, Judge Colopin.
Karen Cherise.
These issues, the court found that in regard to the condonation, there were 2 or 3 days unexplained but where the president was late and he asked for condonation. The other explanation by the
second and third
was that they believed that there was an agreement. This was never raised at the case management. And we found that because it was never raised at the case management, because there was no response to the letters, that they were in right to do what they did. So let's put that aside. Then, just one sec, I'll come back. Then in regard to striking out, we asked the question about what the prejudice was, because there's got to be a purpose to the striking out. It's got to contain something which shouldn't be there for material reasons, not just because it happens to be a duplication or a something that's added in that could have been in a different place. What would it have helped you, other than on the question of costs, if we would have struck out certain of the documents which you requested the court to do? How would that have changed the course of the matter?
No. Strike out, I'm afraid, is not about changing the course of the matter. Strike out, the purpose of Rule 615 is about getting rid of irrelevant matter. It's got nothing to do with changing the course of the matter. So if you can say to me, how would it have helped me if the public protector's report was not put there, or if the judgment of the High Court was not put there? Well, it's not about helping me. It's about, as I said, even helping the appeal courts. The appeal courts are now going to have to go through the same reams of irrelevant documents. Surely, Justice Wayner, there's no court that can condone such a thing, really. The purpose of Rule 615 is exactly to weed out that kind of thing, to introduce discipline, if you like, in how we do our work. So I mean, I can come and put in copies of the business day and this, that, and the other. The court must say, no, you can't do this, Mr. Mpofu, because we now have to go through all this and find some little article on page 20, which you are referring to. But let's go back to the issue of the case management. The case management was absolutely irrelevant. Case management happened on the 28th of May.
Now, the point of the case management is that it wasn't raised at the case management.
It was, by the way. It was raised by me. I don't know where the court got that. I saw that. It was raised by me, by the way, in the case management meeting. But the court says it wasn't.
Okay. Can I perhaps just you have some assistance. I think you dealt with the strikeout as part of the basis for leave to appeal. You're now dealing
Yes.
with it simply on the basis of it advancing the bias argument.
Absolutely. Absolutely.
But Mr. Mpofu, it's just past 10 now, so I think you're doing quite well, and you should be able to conclude by about 15:15.
I will try.
Okay, good. Thank you.
Yes. Okay. Then let me do it like this. Then on judicial bias, because I am avoiding exactly this. There's no point in us debating now that no, we did this because of that or whatever. I speaking for myself at least, I accept that the court did what it had to do. But the point here is a perception of bias on the part of the litigant. It's got nothing to do with me. And this issue of judicial bias, has been spoken about in dark corners in South Africa. I think we must bring it to the fore. I do not want to live in a country where people know the outcome of a case before the case happens, simply because it's so-and-so versus so-and-so. So if there are any people out there who think that is what is happening in our country, rightly or wrongly, then this issue must be brought to the public fore and debated honestly, not defensively, but honestly, so that the public out there, not just Mr. Magashule, must be assured that it's a coincidence that certain people win time and other people don't win. So and it might well be, I don't know. But if it is, then we must debate it, and that's why Mr. Magashule insisted that this ground must be debated, because he felt strongly, by the way, even in court, we had to restrain him because he felt very strongly, particularly at the point, and the most important issue here is what we call prejudging the case. Because you'll remember I raised the issue of the court giving a ruling about the authority of Ms. Duarte in the context of the intervention applications, and actually giving reasons, which was, with the greatest respect, incorrect or inappropriate. Because what that does, to me as a lawyer, it might mean one thing, but to a litigant, all it says is that, what is the point of my lawyer even arguing this point about Ms. Duarte's authority if this court has just given in front of my eyes a judgment that says that argument is wrong? The pre-judging means exactly that, his lawyer saying anything about it, the judgment has been granted. It's almost like you can come to court and the court says, well, let me first tell you that I'm giving you a judgment on one of the issues, but I'll listen to you tomorrow. Which litigant would not feel about that? And the starting point is what was said in Hamata versus Chairperson Peninsula, which is at paragraph 65 of our heads. And I like that because it dispels of basically what we're not saying. What we're not saying is that judges come to a case like robots. I, for one, and now I'm speaking for myself, I don't believe in the so-called objectivity and neutrality of judges or anybody or of human beings. There's no such thing. But there is, because we all come to life with our life experiences and our predispositions and so on. That's fine. But there is such a thing as absence of bias, which is independence and impartiality. and that is a completely different kettle of fish. There, all it means is that you must have an open mind and be open to persuasion. This is what Sope JP said in Hamata. And this statement, by the way, also comes out in Delil versus the Speaker of National Assembly, 1998, 3 SA 430 at 444. It says, quote, very careful here. It is our view that it is not bias per se to hold tentative views about a matter. And that's why I like this quotation, because it makes it clear that that's not what we're about. It says, it is human nature to have certain prima facie views on any subject. A line must be drawn, however, between mere predisposition or attitudes on the one hand and prejudgment, which is what happened in this case, of the issues to be decided on the other hand. Bias or partiality occurs when the tribunal approaches a case not with its mind open to persuasion, nor conceding that exceptions could be made to its attitudes or opinions, but when it shuts its mind to any submissions made or evidence in support of the case it has to decide. No one can fairly decide a case before him or her if he has already prejudged it. And it's just that simple statement. No one can fairly decide a case before him or her if he has already prejudged it. It doesn't matter who you are. You could be the best person in the world, Mahatma Gandhi.
Mr. Mpofu, just to get clarity, and I fully agree with you that one should not shy away from raising in a public court issues around bias. Equally, in raising them, I think the court would need the fullest clarity with regard to, and that's why my question was put to you. Are you saying that this case was determined on the basis of a prejudgment?
No, okay, no, okay.
No, I'm just saying,
yes.
the authority that you relied on now, are you saying that that is applicable in this case?
Yes, I am saying it. If I can, let me just finish. I'll come to your question. Let me just finish the quotation. It says, thus, and it also speaks to your question, Justice Colopin. So, thus, prejudgment of the issues to be decided, which is in a sense prejudice, constitutes bias. So, by definition, so if my answer to your question is yes, which I'll come to now, then that sentence covers it. The prejudgment of issues to be decided, which in a sense prejudice, constitutes bias. The entire proceedings become tainted with bias. So I'm saying, now let me come to your question. Yes, we are saying that the matter was prejudged, and that and I'm not saying that in the overall outcome of the case. I'm talking about the specific issue of the authority of Ms. Duarte. Remember, that is a pivotal issue in this case, which would determine whether the suspension was lawful or unlawful. So prejudging that issue is just as good as prejudging the whole case in a particular sense here. So I accept and concede that the prejudgment, the perception of bias on the part of the applicant was on that issue, but I say that that issue was material. And that issue, as we raised it, and as I say, let's put ourselves in the shoes of a layperson who actually hears what he calls prejudgment. I said it, you know, Justice Colopin. I said even at that point, I know that the court will once it hears my argument, it might be swayed, and I believe that. But this case is not about me. Mr. Magashule reasonably, in this case, believes that the case was prejudged on that point. Why is it reasonable? Because it happened in front of the entire country and everyone. And that is why it says in, if you go to paragraph 62 of our heads, SARFU deals with this very, says courts, it was quoting R versus D, which is the case that we rely on. It says courts have rightly recognized that there is a presumption that judges will carry out their oath of office. That's what I was expressing. A presumption of impartiality. We all know that. This is one of the reasons why the threshold for a successful allegation of perceived judicial bias is high. We accept that as well. Perceived, not actual. I'm not talking about actual bias. However, it says, despite this high threshold, the presumption can be displaced with cogent evidence that demonstrates that something the judge has done gives rise to a reasonable apprehension of bias. That is on all fours with what I'm arguing. Something the judge has done in this case was to give a judgment before the argument. That's cogent evidence of that. And it demonstrates, therefore, that there's a reasonable apprehension on the part of the litigant. And the importance of this, finally, in the context of here, because remember, there's nothing you can do about this now. You are functus officio. So whether you are biased or not biased or perceived to be biased and so on, we're not there now. We could have asked for a recusal, we didn't, and so on, so we can do all that. But the relevance of this is in the context of the application before you is the following, is that such a matter, with the greatest respect to the three judges, is a matter that must be referred to another court, so that another court of neutral people, not yourselves judging yourself whether you were biased or not biased, but somebody with a fresh mind will then say, no, these judges were not biased. And it's important even for this court that it is that happens. And the importance of that is in the Sasol Intrachem case, which is at paragraph 69 of our heads. And this is what it says there, Justice Colopin. It says, to summarize, in cases where it was held that the presiding officer ought to have recused himself or herself at the outset, but failed to do so, the entire proceedings before the arbitrator or presiding officer are a nullity. But here's the important part. It says, in cases where it is found that the arbitrator or presiding officer did not have to recuse himself, like this one, or herself, despite bias, the appeal court generally has a discretion to cure any defect, which in turn will depend on the facts and circumstances of every particular case. In other words, it then becomes the duty of the appeal court to cure that defect, and that alone is a reason to grant leave to appeal. And then it says, bias may nevertheless be so severe and pervasive that it cannot be cured other than by a complete rehearing of the matter, or the facts may be of the kind encountered in Rondelia versus Roll. So again, I pause there. Even if it is of that type, the rehearing can only happen not in front of you, but in another court. Then it says, whether court of appeal or review, depending on its powers, may cure the irregularity or perceived irregularity. The guiding principle is that a litigant has a constitutional right to a fair hearing from the outset to its conclusion, in other words, including appeal. The hearing must not only be fair, but must also be seen to be fair. Anything less than that would not suffice. The remedy employed must cure the irregularity. It must restore the right. Generally, nothing less than a complete rehearing would be required. And therefore, as I say, that is on its own a ground to grant. And then the final submission in that regard is this. I can't find the case now, but one of the cases that we have cited makes this point, that this is important not just for the appellant, it's also important for the three judges in this particular case. Why is that so? Because if Justice Colopin, you say, for example, Ms. Mpofu, we were not biased, or there was no reason for us to be perceived to be biased, then everyone's got, well, what is he going to say? He's defending himself. It is much better for this court to be absolved by another court to say that court was not biased than for itself to absolve itself, so to speak, number one. Number two, it's more important for this court not to shield itself from scrutiny, or to be seen to be shielding itself from scrutiny.
We follow that up, Mr. Mpofu. I think what you're really saying is that we shouldn't be biased in considering the argument of bias.
Absolutely.
Mr. Mpofu, that brings you smack on target.
Prejudge it. Yeah.
That brings you smack on target to 10:15. Are you going to ask then that the application be granted?
Literally 3 minutes just to round up. The point, therefore, is this. If you take then the three pillars, the first pillar, which were the issues of condonation and what have you, we've argued that. Then we go to the second pillar, which are the merits. We've highlighted what we think. As I say, we didn't argue all the issues that are in the notice, but we took out what we think are the 4 or 5 punchy areas where leave may be granted. But we're obviously not abandoning the other ground. And then the important one is this issue of judicial bias. The reason we isolated it, Justice Kolapen, is for the reasons that you summarized now, but also because that ground straddles Section 17A1 and Section 17A2. In other words, it is a ground for reasonable prospects of success, but it also falls under another compelling ground why leave should be granted. And I've already argued why the other compelling grounds, such as the general importance of the case, the court itself recognized that seriousness of the matter and so on. So this is not just a normal case. It's a case, of course, it involves normal people, even if they are presidents or secretary generals and so on. But it's a case that has a pervasive nature in our body politic and in our life, particularly, as I said, in times like this. And the fact that the Ramakat case might have been not applied correctly is itself, those are all the extraneous grounds, irrespective of the Section 17A1 ground. So that's why that issue was isolated, because it covers both, and it's an issue, as we said, unfortunately, with the greatest respect, that should not be determined by yourselves, by another court. As a court, please.
Thank you, Mr. Mpofu. Thank you very much. Thank you for keeping within the time as well. Good. Thank you, Mr. Trengove.
Thank you very much, Lord Malady. I shall share our submissions with my own friend, Mr. Manetti. He will address all the issues on the merits of the case, and I will address the other issues. So if I may start then with the issue of condonation. It's an issue dealt with in the judgment at paragraphs 76 to 78. An extraordinary argument for two reasons. The first is that an applicant can say that the rules are that in an urgent application, the applicant can determine deadlines, and if the respondents don't keep to them, that the respondent then seeks the condonation of the court. That's an extraordinary submission, and there's no justification for it whatsoever. But the other submission is also that my learned friend doesn't tell us how that would make any difference to an appeal. It's irrelevant to an appeal. But let me start with the first proposition. The surprising submission that when an applicant brings an urgent application, in other words, an applicant who brings an application without complying with the rules, can not only expedite the application, but can prescribe to his opponent what deadlines to keep to, and that the opponent then needs the condonation of the court. Now, the only justification they rely on for that proposition is the Republikeinse Publications judgment. But as this court noted, the judgment is not authority for that very proposition. And in fact, they quote the judgment conveniently, an English translation of it, which is even more convenient, at page 8 of their heads of argument. And in the underlined section, this is what the court said. Now, this is the high water mark of their case on this issue. If an applicant acts in terms of this rule and informs the respondent that he regards the application as urgent, it follows, in my view, that the respondent, and here comes the important part, that the respondent is obliged in the sense that he runs the risk of an order against him by default and entitled to provisionally accept the rules which the applicant has adopted. When the matter comes before the judge, he can object. So it isn't authority for the proposition that you need the judge's condonation. It merely says you better stick to those rules, or otherwise default judgment might be taken against you. But when you come before the judge, you can object. Well, that is what we do.
Mr. Trengove, as I understand the argument, the essence of it is that in an urgent application, the applicant is given authority to truncate the time frame set out in the rules. And in truncating those time frames, the applicant is also entitled to put certain time frames within which the respondent should respond, in other words, in filing the answering affidavit. If you fail to comply with those time frames, you need to then apply for condonation. That's my understanding of their argument.
That is indeed the argument, but it's the last part for which there's just no authority. Remember, you need condonation when you fail to comply with the rules of court, not with the stipulations of your opponent. And the only authority on which they rely for the proposition that the respondent is bound by the applicant's stipulations is Republicaanse Publications, which doesn't say that you are bound. It says you are obliged, and then says, in the sense that he runs the risk of an order against him by default. That's the only sense in which you are obliged provisionally to accept it. In this case, the applicant set a ridiculously tight deadline. The respondents did their best. There was correspondence about it, and the matter was overtaken by case management. Remember, urgent applications aren't well measured and organized affairs. It's a bit of a rough and tumble business. In this case, both sides cooperated. The matter came before case management, and there was ultimately no harm done to anybody because everybody had a sufficient opportunity to state their case. The trial was not heard on the original date for which the application was brought. It was arranged, and it was heard by a later date arranged by case management. So with respect, there is absolutely no justification for the proposition that you ought to have refused condonation simply because the respondents did not comply with the applicant's unilaterally imposed deadline. If I may then deal with the strikeout application. What is equally extraordinary about the strikeout application is that it's an application to strike out documents which the applicant says are irrelevant. Now, we submit with respect that you correctly dismissed the application, but what if you erred? What if you should have granted the application? If those documents are irrelevant, then they will by definition make no difference to the outcome of any appeal or of this case. It is a purely interlocutory procedural arrangement, and it should play no part at all in the assessment of prospects of success on appeal. Because if it's correct that the documents are irrelevant, well, then they have no influence on the case at all.
Sorry, Mr. Tendrov, could I just ask, to the extent that you may be correct that the causal link between those rulings and the ultimate determination of how the appeal, if it gets to a higher court, might play itself out, might be a tenuous one. But would they nevertheless be relevant, those rulings, in the argument around bias? And I know Mr. Maneche might deal with that, but would that be something that you will be returning to?
Yes, I'm going to deal with bias, and I accept
that
if the court displayed a pattern of partisanship, then if the pattern manifested in these findings, then that's relevant. But it's otherwise entirely irrelevant to the appeal. Okay. Take the judgment that, remember why the president annexed the public protector's report and annexed the High Court judgment on it. It was because Mr. Magashule had said that the president had been accused of corrupt vote buying, and that those accusations are before the courts. So it was important for the president to show that the accusation was entirely misconceived. Not only that the accusation was false and groundless, but also that no such accusation was before the courts. Something else was before the courts, and the president had been totally vindicated. you'll be happy to hear that the High Court judgment has since then been upheld by the Constitutional Court. But that is not the point. The point is that the President used the Public Protector's report and the High Court's account of what was in issue in the case as evidence, factual evidence, of the matters before the court, which was not an accusation of corruption made against the President, as Mr. Magashule had contended without any justification at all. So it was part of the President's factual refutation of scurrilous and unfounded accusations made against him. But again, the high water mark of all of this is that these documents are irrelevant. Well, how does that then help on appeal? I then come to bias. And I've listened to my learned friend's argument, which has really shifted. I thought ultimately was confined to your finding on the DSG's authority. Now, I will deal with the DSG's authority shortly, but let me ask you to go to their heads of argument to identify what it is they say, the case they make on bias. And it starts at page 16. And it's an extraordinary accusation in paragraph 51, which is the introduction to their contentions on bias. And it says the following: the judgment of the court a quo is littered with a plethora of examples which demonstrate deliberate distortion of the facts and the case of the applicant to the benefit of the respondent, all with the aim of justifying the predetermined outcome by the court. No perception of bias, no subtleties here. They accuse you of deliberately and dishonestly giving a judgment to favor the one side over the other. Now, I've never seen this, and I don't think there's any precedent for it in our jurisprudence, of a bias case which is founded on an allegation that a bench of 3 judges have given dishonest judgment deliberately to favor the one side over the other. Now, it doesn't stop there. The same theme is carried on. At page 18, in paragraph 52.7, these are the respects in which you are accused of being biased. 52.7 says, in failing to give any consideration to the jurisdictional requirement of Rule 2570 as they stand, because doing so, this is your motive, because doing so would demonstrate the failure by the respondents to follow their own processes. So you've made that finding because it would otherwise expose the respondents. Over the page, page 19, at the foot of the page, the last sentence in 52.10, the court parachutes its own analysis and gap fillers to come to the conclusion that the suspension letter was invalid when the first respondent makes no case whatsoever in this regard. Again, an allegation that you deliberately made false findings in order to favor the respondents. Page 20, at the foot of the page, paragraph 52.13. The deliberate failure to accept and refer to common cause facts between the parties. Deliberate failure, I mean, again, it's a dishonest judgment in that you deliberately ignore certain facts. And then lastly, at page 21, paragraph 52.14, the court, having been presented with evidence on the re-engineering, recharacterization, modification and/or amendment of the step-aside regime, and the consequent narrow and selective application as a result thereof, ignored the facts and the relevant background thereto for purposes of assisting the respondent. That's your motive. For purposes of assisting the respondent. in its justification of the approach to the step-aside regime. So it is not a delicate case about a perception of bias. It is a full frontal attack on your integrity and your honesty in giving the judgment you did. So that is the one extraordinary feature of it. The other extraordinary feature is that there is absolutely no evidence to support it. None whatsoever. The argument is based from beginning to end on a contention that says, I argued X and you argued Y, and therefore you're wrong, or therefore you're deliberately wrong. But the mere fact that the applicant's case was wrong and held to be wrong in numerous respects doesn't begin to make a case of a perception of bias, least of all actual dishonesty. So that there is absolutely no justification for the extraordinary case made in the heads of argument of a deliberately dishonest judgment. Ultimately, the only bit of evidence on which my learned friend relies, beyond the category of saying, well, I made these submissions and you found against me and therefore you're biased, is this the fact that you had given a ruling on the authority of the DSG in one of those preliminary joinder applications. But so what? What were you meant to do? It was an issue that was squarely raised in one of those applications. You raised it as you were required to do. You gave reasons for it as not only as you were required to do, but commendably so that everybody could know why you came to the conclusion you did. Remember, that was a ruling in a different case, and it was not binding in the case before you. So that it was open to the parties, if they believed that you were wrong, to submit to you that you were wrong. The mere fact that a judge has in a previous case determined an issue of law that comes up again does not found a case for bias at all. So with the greatest of respect, you did absolutely nothing wrong. You had to decide the issue. You did decide the issue. You did it openly and publicly. And there is no justification for any suggestion that you impermissibly then proceeded to the main case. But even if I'm wrong.
Mr. Trengrove, would it be correct to say that that ruling was made in a different case? It was in a joinder application to seek joinder in these proceedings. So until the joinder was granted, that was not part of this case. Is that what you're saying?
No, absolutely. It was part of this case. And the list that you determined was not a list between Mr. Magashule and the respondents. It was a list between the respondents and the applicant for intervention. But let me say that there is another reason why this point doesn't avail them, and that's this. You gave that ruling openly and publicly, and my learned friend made mention of it. I can't remember what he said. My vague recollection is that he said that that he shrugged it off, but my memory is very, very unreliable, and don't make anything of it. But what they're not allowed to do is to sit there with full knowledge of the facts, take their chances on the case, and bank their recusal point in case the case goes against them. The law is absolutely clear. If you have a recusal complaint, then you must raise it at the first available opportunity. You can't take your chances, bank the point, and then use it when the case goes against you. And that is exactly what they're trying to do in this case. So that with respect, for two reasons, is an unfounded attack. Our own friends then say that there are other compelling reasons. Even if they do not have reasonable prospects of success, there are other compelling reasons. Well, with respect, there's absolutely nothing compelling about them. what is compelling is a reason to refuse leave. And let me submit this. The step-aside rule is an important and lawful mechanism designed to ensure that people suspected of corruption do not occupy positions of power. And it is important that these mechanisms be effectively enforced and not be undermined by endless spurious litigation, so that if there are factors beyond the prospects of success which play a part at all, then we would submit that they would militate against an appeal and not in favor of it. And there is lastly the supplementary notice of appeal, which tells you that if the applicant gets leave to appeal, they're going to make an application to the SCA to introduce new evidence. Now, this is an extraordinary contention. My learned friend has already accepted that it's entirely irrelevant to the issues before you. Well, why is there a document on record which is entirely irrelevant to this application? It's all the more so in paragraph 79 of their heads of argument. That's on page 33. They explain, they say, the inclusion and relevance of this section in the application is obviously not to introduce the new evidence to this court, which is functus officio, but to support the overall submission that, in the unlikely event of such evidence being admitted, then the reasonable prospects of success will be significantly advanced. So not only is it irrelevant, but they say it's unlikely that the evidence will even be admitted in the SCA. So why do we have this document? This is a scandalous attempt to use the platform of this court to malign the respondents. My learned friend used it as a platform this morning to accuse the president of corruption. And there's not only is it irrelevant, there is absolutely no evidence. There is no evidence in support of these contentions. I learned of these contentions in the media before I saw the document. Its purpose is clearly to abuse the courts as a springboard for scurrilous insult of the president and of the respondents without any foundation, in fact, at all. The document doesn't even claim to be supported by any evidence. So we submit with the greatest of respect that the application for leave to appeal should be dismissed with costs, including the cost of free counsel, on the attorney and client scale for two reasons. Firstly, the scurrilous and unfounded attack on the bench, for which we submit is scandalous and for which there was no justification at all. And secondly, for the introduction of this supplementary heads of argument merely to abuse the court's platform to insult the president. And there is no other justification for it. Thank you, my lords, my lady. My learned friend, Mr. Manetti, will address you on the rest of the matters.
Thank you, Mr. Drengov. Mr. Manetti.
Thank you, my lords and my lady. I will address the 4, 5 or 6 grounds for leave to appeal, which my learned friend addressed under the heading merits. And I will follow the note for oral argument that we sent this morning. And in that context, also try to respond to some of the additional submissions that were made orally this morning. The first point is that is the question whether this court was correct in its characterization of Rule 2570 as not being a rule of a disciplinary nature. And that the court dealt with in the context of whether the rule was inconsistent with the constitution of the ANC. Now, the first thing to acknowledge is that the applicant does not attack the finding by this court at paragraphs 99 and 100 that Appendix 3 is only concerned with disciplinary proceedings. So that as a starting point is not disputed. And so the question they challenge now is the finding that Rule 25.70 does not constitute a rule of a disciplinary nature. And the only contention they make really is that one must look at the location of the rule in the Constitution, firstly. And then they also say, well, all compulsory summary suspensions are by definition disciplinary processes, and therefore this court erred. But with great respect, the approach to interpretation is now settled in terms of the Indomani judgment. And one starts with the wording of the rule, looks at its purpose and its context. Its context is not just limited to the location, it's also takes into account its history. The court has spoken about the history of the rule from 2012. And when one has regard to the wording, the purpose of the rule, it's quite clear that it is not there to start a disciplinary process. The court said at paragraph 103 of its judgment that there are no disciplinary charges that precede the invocation of the rule, and no disciplinary hearing or steps are contemplated at all under paragraph 103 of the judgment. Those findings are not disputed, and the contention that just because the contention they make that all compulsory summary suspensions are generally disciplinary in nature, therefore the conclusion must be reached here also that the rule is disciplinary is simply incorrect, because it disregards its wording and its purpose. And the location can't undermine that, because as the Indomani points out, the starting point is the wording of the provision, and the court can't do violence to the wording of the provision because it believes in its own judgment there might be a different purpose to be served. So we submit that there's simply no sound or rational basis for the SCA to differ with that conclusion. The second follows on that finding. It is the challenge to the court's finding that the suspension under Rule 2570 is precautionary in nature. And the first point to make about, and this was in the context of debating whether audi applies or doesn't apply, and the discussions of Long and the other cases, our learned friend picked out Grogan and says, well, Grogan is against the finding of this court because the learned author says that there are only two types of suspensions. One is punitive and one is precautionary. Well, the current suspension is clearly not punitive. Mr. Magashule is not being punished for any kind of conduct. It can only be precautionary. And the strained interpretation that they put is, well, if it's precautionary suspensions only apply in the context of employment law. But that can't be correct, because the very cases they cited, Hamata, deals with discipline in the student context. And in there are provisions for suspension too. And even in that context, suspension can be precautionary. In other words, it's not punitive. It's pending other processes. It might be disciplinary, maybe criminal proceedings that are external to the body, but it's all precautionary because it is not punitive, no finding of guilt, not punitive, and you're suspended on full pay in this case with Mr. Magashule. So there's simply no doctrinal or issue of principle on which one can draw the distinction between the application of precautionary suspension in an employment context and in this context. That's the first basis on which the argument is made. The second basis, which is a bit belated, is to call in aid paragraph 3.3 of the guidelines and say, well, even in the guidelines themselves, it is anticipated that Rule 2570 could be disciplinary in nature, or could precede the institution of disciplinary proceedings. But that provision is quoted out of context completely. The reason I say that, and you will recall from the address, the main address of my learned leader, Mr. Trengo, during the main case, when he tried to draw the different categories that are covered in the guidelines. one of the categories is dealt with under 3.3. That is a category where the criminal complaint for which you're prosecuted only also constitutes misconduct under the ANC constitution. So it says in 3.3.1, conduct leading to a member, office bearer, or public representative being indicted to appear in court of law or on any charge, especially that of corruption or any other serious offense, could also constitute an act of misconduct in terms of Rule 2517, not 2570, of the ANC Constitution, for which disciplinary proceedings could be invoked and instituted against such a member, office bearer, or public representative. Now, when that is the case, my lords and my lady, the power to suspend is not that under 2570. It is under the rule under the ANC Constitution, which deals with disciplinary proceedings, and that is rules.
Mr. Manechi, are you saying that the architecture of the rules contemplates that someone who's charged in a court of law can be suspended under 2570, but equally the organization could consider disciplinary action arising out of that charging in terms of 2517?
Precisely.
And when they do so in 2517, that may well characterize it as disciplinary.
Yes, but the suspension is not carried out under 2570.
Sure.
Under paragraph 3.3.8, and the court can see this. It starts from 003-991, and the paragraph I'm referring to is under 003-992. It says, in terms of rules 25.56 to 25.69, and then it quotes the rule, the NEC, NWC, PEC, or PWC, as the case may be, may at any stage prior to the commencement of disciplinary proceedings against a member summarily suspend the membership of that member in accordance with the provisions of this rule. So the suspension there is taken in terms of the different rule, and then there's provision about what steps must be taken before such a suspension can be invoked. So the 3.3, where a suspension is implemented because the criminal conduct also constitutes disciplinary proceedings, is dealt with as a disciplinary matter as opposed to 25.70. Okay. So that second basis, with respect, does not assist the applicant at all. So once that is out of the way, the only question for the court was, was a hearing required if this suspension was precautionary? And the court looked at those various cases, culminating in the long judgment of the Constitutional Court, that where the suspension is precautionary, a hearing is not required. But the court didn't stop there, which is very important for purposes of showing prospects of success on appeal. The court went further and said, even if we are wrong, and it may be that on the facts and circumstances of this case, a hearing was required. In fact, Mr. Magashule received an opportunity to be heard. And that is where the court looked at the hearing in respect of the appearance before the Integrity Commission, the various meetings of the NEC and the NWC at which Mr. Magashule appeared, the meetings with officials which happened post that, recall with the Treasurer General, also at the President's house, all of those that happened even after he had done the roadshow to consult previous leaders of the ANC. All of those, we submit, support the findings of this court that even if it were wrong on the analysis in respect of precautionary suspension, which is from the court analyzes that from 108 to 116 of its judgment. Even if that is wrong, at paragraph 193 to 204 of the judgment, the court considers whether the facts and circumstances of this case, in fact, support the conclusion that there was an opportunity to be heard. And it's important, allied to this submission, that the applicant does not challenge the principle of law that audi is not a inflexible rule, that it is flexible, depends on the facts and circumstances of each case. And the court quoted with and there's no challenge to that, the academic writing by Professor Hoekstra, which says it is an opportunity to try to influence the decision that might be taken adverse to your interests. And all of these instances where the court identified that he had an opportunity to influence the outcome of a decision which he knew was going to affect him adversely because he had been indicted already. And he was sitting in all of those meetings, including the very last meeting of the NWC on the 3rd of May, when the instruction was given for the letters of suspension to be issued. So we submit that there's no sound or rational basis on which the SCA would come to a different conclusion from what this court found. Then the third point, the third ground is the jurisdictional requirements of Rule 2570 and the authority of the DSG to issue the letter of suspension. My learned friend said this, I think he said, was the worst of these grounds on the merits. I think what he meant was the best case for the applicant. We would submit that is one of the weakest, in fact, because the first challenge is that the DSG did not have authority. But the DSG's authority is conferred by the Constitution of the ANC in Rule 16.9, where the wording which the court referred to and summarized at paragraph 217 says, the Deputy Secretary General shall assist the Secretary General, deputize for him or her when necessary, and carry out the functions entrusted to the Secretary General by the National Conference, the National Council, the NEC, the NWC, and shall be an ex officio member of the NWC. Now, let's start just by dispelling, dealing with an obvious requirement, that it must be necessary before the DSG can deputize. The applicant accepts that he couldn't suspend himself because he was hopelessly conflicted. So that's common cause, is not disputed. So the only thing that remains is whether the rest of the provision gave the DSG the power. Of course it did. In the absence of the Secretary General, it became necessary for the DSG to carry out the instruction entrusted by the NWC upon the Secretariat to issue the letters of suspension. And the court will recall that entrusting that function was carrying out the decision of the NEC that those indicted who have failed to step aside in the 30-day period must be suspended. So it was carrying out that function. And they quibble with the finding by the court at paragraph 220 that the court said the DSG was delegated that power. But and they say you don't mention by who. But the rule, the facts discussed in the judgment are very clear, that there is an NEC decision and there is an NWC decision which instructs that suspension letters must be issued. And the applicant can't issue that suspension letter, but the Secretariat is entrusted with that function. Now, it's clearly, in the context of the rule, the function falls on the DSG. It's a matter of semantics whether one construes that as an instruction, an entrustment of the function on the DSG, or a delegation on the DSG. But on the whole, the court is absolutely right that the DSG had to carry out the function. It's an instruction of the NEC carried out by the NWC, given to the Secretariat, and the Secretary General can carry it out. It follows. And you'll recall that he initially contended that in his absence, because he's the only person who can suspend under that rule, in his absence, only the NEC could suspend him. Of course, he's now realized the folly of his ways, and in the heads of argument now says the Treasurer General should have been the one to suspend him. That was not the case made in our court. But in any event, the real instruction was to the Secretariat in terms of the rule. And then the second challenge is they say the DSG did not herself independently satisfy herself that it was in the best interest of the ANC to suspend the Secretary General and like persons. My learned friend argues that, well, as long as he says the NWC was satisfied and she was equally satisfied. So there's a half-half satisfaction. It's ultra-virus because the half belongs to a body that should not have been satisfied. With respect,
Mr. Manager, sorry to interrupt you, but in fairness, although in argument it's put differently, but if I recall in their papers, they did say why the DSG and not the Treasurer General. So the name of the Treasurer General did feature in their papers.
I accept that correction, Justice Malachele, but it makes no difference to the submission I've made. The DSG was still the proper authority because the constitution of the ANC says it is the DSG that deputizes and carries out functions in the place of the SG, not the Treasurer General.
Thank you.
Yes, and I was just going to the point about equally satisfied. Now, the court dealt with that at paragraph 214 of the judgment and was referring really to the evidence of the DSG in her affidavit in answer on behalf of the respondents at paragraph, I believe, was 68.3, where she says that the NWC believed it was in the best interest of the ANC to suspend those implicated in line with the NEC decision. And she's, in a separate sentence, says she was equally satisfied, meaning independently of the NWC, even if she was thinking at the same time as the NWC was thinking about the matter. Independently of the NWC, she was also satisfied that it was in the best interest of the ANC. So the jurisdictional requirement of her independent satisfaction is testified to on oath by the DSG.
Mr. Manager, can I just interrupt you again? Judge Kolapen, I don't see Judge Weiner, unless she's listening, but I was just checking on the list here. She doesn't seem to be...
I can see her.
I am here.
Yes.
Oh, okay. On my side, you don't seem to appear. Okay, thank you.
Yes.
That's okay.
So our submission is simply, there is no countervailing evidence on which the court would be justified in going behind the oath, of the DSG when she says she was independently satisfied. And that is done on affidavit, which is where the evidence should be. One doesn't go around looking in annexes to see whether there is anything to counter that. There's nothing to counter the fact that she says she was independently satisfied, and the court was entitled to accept her evidence. The next point, and I think I'm probably at ground 4 now, is this idea that the court committed an error or misdirected itself on cases and authorities, especially in relation to Section 19 and Section 36 of the Constitution, and the application of the Latif principle and the application of the audi principle. We submit that there's nothing closely resembling any prospect of success on that. And I start with the Ramakat's argument. So, and that is based on Section 19 and Section 36. We would submit that the applicant conflates two separate inquiries, and the court dealt with the separate inquiry properly, and it did so at paragraphs 136 to 140. It said, recall this was in the context of 2570 breaches the Constitution, firstly, and then the actual suspension also breaches the Constitution and breaches the Constitution of the ANC, the National and the ANC. Now, the court said, first, let's look at whether 2570 breaches the National Constitution, in other words, Section 19 of the Constitution. And it said, in terms of the Ramakat's judgment, it's quite clear that the regulation, the internal regulation of a political party is left to the political party, and cited the various provisions of the ANC Constitution, which talks about how you become a member, the kind of oath of office you take, of membership you take, and the obligations you undertake towards the ANC. And if you fail, the ANC is entitled to say, we can suspend you. And that might be suspension of a disciplinary nature or suspension under 2570. That is perfectly consistent with the Ramakat judgment. Otherwise, it would mean that the ANC, as a voluntary organization, would not be able to suspend its members when they breach the obligations they've undertaken. Now, that's the first inquiry. If you had found that 2570 breaches Section 19, then you would have gone on to a Section 36 analysis. But because you concluded rightly at paragraph 138 that it doesn't, Section 36 did not arise. And then the next inquiry was, well, assuming 2570 is consistent with the national constitution, was the suspension itself nevertheless inconsistent with Section 19? And the analysis you conducted, Justices, was first, there's no contention that there was no reasonable basis or justification for the suspension, so that's out of the way. The only contention was that there was no fair hearing, but that you dealt with and said there was a fair hearing. It's precautionary, but if there was need for a fair hearing, there was a fair hearing. So the suspension is then consistent with the Constitution. That's the end of the inquiry. You don't have to subject the suspension to Section 36 because Section 36 only applies to a law of general application and not to suspensions by the DSG. So that with respect is there's no prospect of success there. Then the next point, the Latif principle was not addressed in argument, but the court was quite correct. It looked at this principle at paragraphs 227 to 228 and said that principle doesn't entitle you to walk away from a deliberately chosen basis for acting. And that basis was Rule 2570. And on the facts, the applicant had not satisfied the jurisdictional requirements of 2570 when he purported to suspend the president. And therefore, that goes out the window. But the court didn't stop there. It went further to look at whether, in fact, even the new ground could be sustained and accepted the submissions of the respondents. Firstly, that the audi principle is not applicable here. This is not the exercise of public powers, it's an exercise of private powers of a voluntary association, and that is dealt with at paragraphs 230 to 233 of the judgment, and said you can't win on that. The new ground doesn't sustain the other argument. In any event, that the delegation in terms of that resolution that the applicant sought to rely on did not say that you now usurp the function of the NEC and the NWC, which is required to give you an instruction or to give you the authority to suspend the president. And none of those had been given in this particular case because the president did not fall within the category of people who were indicted criminally in courts of law. So that too falls by the wayside. The next third point under this main head was this court granted an unsolicited order validating the suspension, the purported suspension, declaring the suspension of the president invalid. So that's part of the complaint about the court descending into the arena. But this is wholly unfair to the court, completely, because the order that the applicant wanted was a declarator that the suspension of the president was valid and remains in place until set aside. So the applicant invited this court to give the purported suspension of the president its imprimatur. Now, even when courts are asked to confirm settlement agreements, courts make those orders as their own orders. They have to satisfy themselves that the order is lawful and can be made. And that's precisely the issue here. Before the court could give the declarator that the president's suspension was valid and remains in place, the court had to be satisfied that indeed that suspension was valid, and it found that it wasn't valid and dismissed that order. So there is no court will come to the assistance of the applicant on that point. There's no prospect of success whatsoever. The last point, the last ground is the narrowing and amendment. With respect, again, there's no prospect here. And the argument is that because the guidelines do not expressly refer to a category of members who have corruptly influenced conference outcomes by the use of money, that means this court should have found that the guidelines were narrowed by the NEC without authority, and supports this argument that there was an ulterior use of the step-aside rule against selective application of the step-aside rule against Mr. Magashule. But that's wrong for two reasons. The first reason is that if a person has corruptly used money to influence conference outcomes, and there are allegations to that effect, that falls to be dealt with under that general category that the court dealt with, which is under 34 of the guidelines, which talks about where a member is facing allegations of corruption. It is corruption, it's clear. It will be allegations of corruption, and they must be investigated. The process goes to the Integrity Commission, and so on. So that's the first problem, and the court was correct in light of that submission that, in fact, the categories are included, the guidelines were inclusive. And that is the analysis by the court from paragraphs 159 to paragraph 181. But in any event, the applicant cannot attack the unassailable finding by the court at paragraph 181 that even if there was under-inclusion, that is not an issue of validity. It's something that must be cured by supplementing the guidelines. There can't be any attack to such a sound finding. And so with respect, even this last ground has no prospect of any kind that the SCA would reverse the judgment of this court. So what the end result is, on the merits, there is no sound or rational basis on which the court can find under section 17(1)(a) Roman 1 that the SCA, that there's a reasonable prospect that the SCA would find again, reverse the judgment of the court on the merits. And so the application falls to be dismissed on that basis. And so I endorse and support the submission made by our learned leader, Mr. Trengove, in conclusion in relation to the order that must be granted by the court. Those are our submissions on the merits, unless there is any question from the court. I think Justice Kolapen, you're on mute.
I'm sorry. Thank you, Mr. Manechi. Thank you to both you and Mr. Trengove.
Thank you. Thank you.
Mr. Pofu, in reply, sir.
Thank you, Justice Kolapen. I'm sure my learned friends will not mind lending me some of their time.
That decision is not for them to make. that would be usurping our powers.
Sorry, I can't hear you, Justice Kolapen.
I say, with respect, that's not a decision for them to make.
A sound problem.
Okay, let me see. Can is that better?
Side. Just a minute, please, Justice Kolapen.
Yeah.
Can you hear me now?
Yes, 100%.
Okay, I was saying that even if they were gracious to give you their time, they would be acting ultra vires, because that's our decision.
Yes, they'll be the wrong functionary to give me the permission.
Yes.
Thank you.
Okay.
Thank you,
So okay.
Yes. No, I'll try and do it enough for now.
Okay.
Yes, let me start with Mr. Manechi, just so that, because I think his is the easier section. So Mr. Manechi makes one fundamental mistake, justices. We are not here to re-argue the case. We are done here. This court is functus officio. So it doesn't matter if Mr. Manechi's interpretation of 2570 as not being part of the total matrix of discipline, despite the heading. He might be right. I don't know. I don't care. But the issue here now is whether our interpretation that 2570, because it's part of Rule 25, must be seen in the context of that heading. That might also be right. So that's all we need. This is an application for leave to appeal, not an opportunity to re-argue the case. So unless if he says this interpretation that 2570 is actually part of 25 is so outrageous that there's no court in this country that might sustain it, then leave to appeal must be granted. It doesn't matter if this court, of course this court will think that, we know what this court thinks about it. We're not here to change this court's mind, but we're here to postulate what another court might do. We're not mad. As I say, the definition of madness is to do the same thing and expect a different outcome. So we can't convince this particular panel that 2570 is not, or rather is part of 25. We know, we can read the judgment. So now and that goes for all his arguments, by the way. But it doesn't really matter. All these things about the DSG was automatically, we know what the court has said. The court has accepted their argument on that. That we're not here to change the mind of the court. We're here to say another court might find that there was actually no delegation. And we've made it very clear, Justices, that maybe let me say this really for the avoidance of doubt, because I said it and it was still found itself in the judgment, unfortunately. We accept that Mr. Magashule could not suspend himself. We accept that. I've said it so many times, and yet in the judgment it was still said that we argued the opposite, which is really frustrating. So we accept that. But what we do not accept is that the fact that Mr. Magashule was conflicted and could not suspend himself automatically means that the DSG, as she put it, it fell on her to simply like manna from heaven. That we don't accept. Okay, so that's the only thing we don't accept. And proof of that is in the exchange that Justice Mulache fortunately assisted, because I was just looking for that passage. The reference to the TG, it only works in the following way, in our favor, at least in front of another court. It didn't work in this court. It is this. Assume that the SG, Mr. Magashule, was conflicted. Assume that the officials realized that he was conflicted for obvious reasons. What did the officials do, Justices? They delegated the entire step aside issue to the Treasurer General. Right? That's common cause. It's in your judgment. Paragraph 175, okay, of the judgment. Just there can be no doubt from a reading of the minutes of 13 February 2020 that in adopting the guidelines developed by a team led by the Treasurer General, the NEC intended to do nothing more than to establish procedures. We know the context in which that happened was the very acknowledgement that Mr. Magashule could not be the leading light in this matter because he had already been charged in November 2020. Okay? So if this argument that it falls directly and automatically to the DSG, then why would the officials, they shouldn't have done anything because it falls. The mere reason that they took it to the TG shows that it is not automatic, that something must be done in order to delegate it to someone. So we accept that it could not be the SG. But the question is, who should it be? That's the question. It should be somebody else because it's conflicted, but who is that person? That person cannot automatically be the SG. That is shown by the mere fact that it was once sent to the Treasurer General. Okay, that's really a very simple proposition. And therefore, the other point, Justices, which makes this even plain, is that we know with common cause that on the 8th, I think that meeting, the actual NEC meeting, the special NEC meeting, which was on the 8th to the 10th, One of the resolutions announced to the South African public was that the DSG is now going to assume the powers of the SG. Why was that done if it happens by osmosis and manna from heaven? Why would it have been necessary for the ANC to announce, the president no less, to announce to the world that as from now, the DSG is going to exercise those powers? Because according to the logic of my learned friends and the judgment, that in any event is what happened. So that announcement was just totally superfluous, meaningless, waste of air. Really, you know, the issue here is that the propositions we make may be right or may be wrong. To say that there is no court that is going to look at the fact that accepting that there was a conflict, that it did not fall, quote unquote, on the DSG. There had to be, even this court, to be honest, could not find it within its power to say when or where the delegation happened, because we don't know where, on what date did this delegation happen. The court simply says the NEC had the power. I just don't want to misquote the court. Sorry. It should be in our heads under A8. Okay, I'll find it, but I'll paraphrase. The court says the NEC has a right to delegate, and then immediately then says, therefore the DSG was empowered. But surely that it can't work like that. Yes, paragraph 220, yes. This is what the court says, this court. The discretion to delegate the power and authority to issue the letter of suspension rested with the NEC and the NWC. Accordingly, the DSG had the authority and power to issue Mr. Magashule with a letter. That word accordingly is completely misplaced. So what if the authority, the NEC has authority? You can't then say jump. It's a quantum leap in logic to then say accordingly the DSG had the authority, because that authority could have been given to the national chairperson, the deputy president, the treasurer general, or me. So the point is simply missed in what Mr. Manecha was saying. Now, I don't think it's necessary to go through all the other issues on the merits because of time. I will simply refer this court, that case that I was said I couldn't find, the case of Mhlauli versus Minister of Department of Home Affairs and another. It's Eastern Cape, Southeastern Cape, yeah. It's 1992 3 SA 635. And the reference there is to a case called Mula, which is quoted at page 639 by Van Rensburg J. And I just want to read, it's like a reference within the reference. That court said, about suspension. The suspension unquestionably constitutes serious disruption of his rights. And here we're talking about, in that case, it was his labor rights. Here we're talking about disruption of his Section 19 rights. So it's the same thing. So and I'll come to that, by the way, just now. The implications of being deprived of one's pay are obvious. And in that case, which doesn't apply here, it was also without pay. But the point is this, it says the implication of being barred from going to work and pursuing one's chosen calling, or you can now here say one's chosen political party, and of being seen by the community around one to be so bad, as Mr. Magashule, are not so immediately realized by the outside observer and appear with respect perhaps to have been underestimated in Swart versus Jacobs cases. Those were cases that were like long, that said it was not necessary to have a hearing. There are indeed substantial social and personal implications inherent in the aspect of suspension. These considerations weigh as heavily in South Africa as they do in other countries. The Swart and Jacobs cases concerned other statutes, but those enactments were not significantly different from the Act in any respect. For the reasons already given, I think that the audi rule ought to have been held to have applied to the suspensions with which those matters were concerned. In this regard, I'm convinced, and I say so with due deference, that those cases were wrongly decided. All we're saying is that this will one day be said about this court by the SCA, that with due deference, the idea that you did not need a hearing simply because it was so-called precautionary suspension, which we've addressed separately, that is wrongly decided. That's all. Somebody will, I'm sorry, Justice.
Sorry, Mr. Mpofu. I just wanted to, I see it's a 1992 judgment, and I think we would agree that there has been quite significant development in the labor arena in as far as the suspension is concerned. The plethora of cases dealing with that. But what I had you reading also is that there seemed to be the suspension was without pay.
Yeah, which is irrelevant.
And we know what the jurisprudence in the labor court have been, particularly where the suspension is without pay. It's almost invariably taken that it's punitive because you're denying the person the income.
Yeah. No, I accept. Okay. I accept that, Justice Mulaki. That's why I said it's not relevant for the purposes, because when he was talking about, the learned judge was talking about the social stigma, let's call it that. Obviously, that's a separate thing to the pay or no pay. And I quoted to this court paragraph 27 of Wachenuka's case, where Justice Nugent, that's Wachenuka, it's an SCA judgment. It will be in the list of authorities, 2004, volume 4, SA 326 SCA. This is what Justice Nugent said about the distinction that I seek. At paragraph 27, the freedom to engage in productive work, and again substitute that for participation in a political party, even where it is not required in order to survive, that is the pay, is indeed an important component of human dignity. As submitted by the Respondents' Council, for mankind is preeminently a social species with an instinct for meaningful association. Self-esteem and the sense of self-worth, the fulfillment of what it is to be human, is most often bound up with being accepted as socially useful. Justice Sachs said the same thing in the case of Masetla. I just don't have it in front of me now. Justice Sachs said in Masetla that, because there the argument was what you are saying, Justice Mulaki, that, Mr. Masetla has been suspended with pay. And Justice Sachs said, men, like other social beings, does not live by bread alone. In other words, the bread being the salary. So the fact that you are paying the person doesn't make a difference to the argument that we are making now. The argument we're simply making is that somebody as high profile as the Secretary General of the ANC, to suspend them, surely in anybody's language, carries with it a stigma of some kind of wrongdoing. People might not know, but when they meet him in the street, they'll say, oh, that guy used to sit in Lutuli House. He's now walking around in the taxi rank in Bloemfontein. So that's the reason why audi becomes important. The Section 36 argument is completely misunderstood. Let me make it plain. Any suspension of a person from participating in a political party is prima facie a breach of Section 19 rights, full stop, right? Because a letter that says you will not participate in this means that your rights in that Section 19 are being deprived. The only question becomes, is that justified? In case number one, it might be justified. Case number two might not be justified. Just like any dismissal from work is bad and painful and so on. But is it justified, yes or no? That's where Section 36 comes in. So for a court to not to even recognize that the deprivation of the participation rights is a prima facie violation of a Bill of Rights, that is so fundamentally wrong that any court, even a court that will find that is justifiable, will find that this court was wrong by not recognizing that I'm sorry, just.
Yeah, sorry, Mr. Mpofu, but that point you emphasized it in your submission earlier on, which is has to do with the interpretation of Rule 25.70.
Right.
But the argument which was raised by Mr. Manager, which I wonder whether you would want to attend to it, is the finding that this court made that if we are wrong in relation to the audi, that indeed audi was applicable in this case, that he was indeed, in the context of a flexible rule as such as audi, afforded that opportunity. So the court concluded that indeed you may have had an opportunity to be heard.
Yes, we've addressed that in our heads, justices. We say that about that. We say the following: that that's what we call the weakest link in the judgment. That's what we call it in the heads, because the argument, with the greatest respect, it's based on a case that you decided, Justice Mulahledi, which doesn't say what the proposition that it is relied on, and that is the case of I had it here now. It's a Mpumalanga case.
It's a very old case, in fact.
A very old case, firstly, but age does not matter. So it's just the inappropriate case, even if it was decided yesterday. That case is not authority for the proposition that audi, in circumstances that I've described, cannot be applied. Let me explain what we're saying there. There's one bullet submission. It is this. Another court might well, another court would find that to say that audi was granted, let's say, for example, before the Integrity Commission, is wrong completely. Because why? One, the Integrity Commission, and I explained this again because Justice Weiner raised this issue about the Integrity Commission. One, the Integrity Commission itself says in its finding, we are referring this matter to the NEC, which is the right body. Two, the Integrity Commission said on the 12th of December 2020. How could that be audi for a decision that's going to be taken in respect of guidelines that are going to be developed in March of the following year? Surely, when we talk about flexibility, there must be limits. You can't have say, no, I'm giving you audi now in case in 10 years' time, I might find something against you. It doesn't work that way. The flexibility that is in audi is that it doesn't always have to be some big office with water in the middle and other people sitting this side or that side. The audi could be in informal ways, but it can't predate the happening of the thing, predate the formulation of the rules, and predate the decision itself, and nothing be done by the non-decision maker. Surely, that's stretching flexibility to absurd limits. So that's the point. Okay, anyway, I want to move very quickly to Mr. Trengo, to whom everything is extraordinary. It's not extraordinary to say that he contradicts himself on the condonation point, because he accepts that Republicans, the case of Republicans says that if you don't follow, and that's the point that Justice Mulahledi put, which was not answered. If you don't comply with the rules, or rather with the timelines as set out by the applicant in an urgent application, those rules, the timelines set up by the applicant assume the status of rules. That's our submission. And if they are what did you call them, ridiculous, then the remedy is not, if for example, we say, look, we're setting the matter down for September, but we want you to give our answering affidavit at 3 o'clock this afternoon. Well, that's ridiculous. But your remedy is not to do that. It is to then put in your papers why it was ridiculous to be given 3 hours for a matter that will be heard in 3 hours in 3 months' time. You don't somewhere just do nothing and then rock up in court and say, well, because those timelines were ridiculous. Proof of that is the fact that Mr. Trengove says, if you don't honor Republicans, then you are in jeopardy of being held in default. The word default means default of the rules of court. So that shows that the timelines assume the status of rules. Because why would you be in default of what? Of some ridiculous thing that has been put up by the applicant. It's because that thing now assumes the status of rules of court, which is the point Justice Molefe was making. And then the case management thing, really, I don't know how case management that happens on the 28th can cure the failure to apply for condonation on the 25th of the month. It beats me. Because if you failed on the 25th, how do you get cured ex post facto by some case management that happens afterwards? Anyway, and then what they do, of course, is to blame the victim. You know, we are the ones who are ridiculous for asking them to ask for condonation when they have breached the rules. Then Mr. Trengove goes on to find it extraordinary that we could dare to accuse the court of bias. Well, I've got news for him. He must read the notice of application for leave to appeal. He almost wants us to shrink like violets into saying, no, we're not accusing the court of bias. Well, we are. We are saying that in our notice of application, we said actual and or perceived bias. Actual, it can be worse than that. That is what the client says, actual bias, and then and or perceived bias. All I said in response to the question put to me by Justice Colapen is that it is not necessary, because we don't have time, it's not even necessary to address the question of actual bias, because the perception of bias is sufficient, and we'll leave it at that. But it's not a secret that our submission is actual and or perceived bias. And that is why we said, whatever the accusation is, the most important thing is that another court will find that this court had no bias, actual or perceived. But that is something that should be done by other people. So if he thinks that we're going to shy away from what our instructions are, then well, he's got something else coming. So he says, he asked this question presumably rhetorically about the fact that a judgment was given by this court on the DSG's authority. He says, what were you meant to do? As if there's no answer to that question. Well, there's an answer. Let me tell you what you were meant to do. What you were meant to do was to find that the application of Mr. Sakane for intervention is dismissed, and Mr. Mtembu or whoever else was there is dismissed, and reasons will be given at the end to avoid the perception of bias. That's what happens every day in our courts. Even magistrate, you have section 174 applications. The magistrate will say, I'm not granting the section 174 application. I'll give reasons when I give my judgment. Why? Because if he goes on to say, well, I'm not granting it because you are guilty, then what's the point of having the trial? That's the answer to that question. And of course, between myself and Mr. Trengove, Mr. Manager, as lawyers, he's quite correct that all these things about the lease and what. Mr. Magashule doesn't know what that means, a lease. The test is not the senior counsel speaking Latin. The test is the reasonable litigant in Mr. Magashule's shoes. What is Mr. Magashule to do when he sees a court making a decision about something that has not yet been argued? Is his perception reasonable or not in those circumstances? Not whether it's correct or not, or whether it shows actual bias or whatever. It's a simple test. We all know it. So it's not the test of the senior counsel who, I did say this, Mr. Sekgobelo is quite correct. I can't remember myself. My memory is probably like his. I can't remember the exact words I said, but I said to the court, I want to place it on record that this is inappropriate, and I myself am satisfied that the court will still listen to me, and so on and so on, and I place it on record. So his lecture that it must be raised at the earliest possible opportunities is wasted, because that's exactly what I did. As soon as that ruling was done, I immediately raised it at the earliest opportune time. I didn't wait for the end of the case, and worse still, which is wrong, to accuse us of now raising it because the finding against us is actually ridiculous. That is what is ridiculous in this case, because if we wanted to wait until the outcome came and then whinge afterwards because the outcome did not favor us, then why did I raise it right up front before any argument, without even knowing whether the court was inclined this way or that way? So we don't need that lecture, I'm afraid.
I think Mr.
Mpofu, take exception to it.
I think, Mr. Mpofu, if I understand the argument of Mr. Trengo, argument goes that at the point when this issue arose,
right,
and in fact, I do recall you making mention that there are some people behind you who are whispering about the decision relating to the DSG, but you, in your own personal capacity, understands what the court was doing.
Yes.
So, as I understand, what he's saying is that at that particular time, you never took issue with the court to say you can't proceed having made this pronouncement.
Yes.
You are now biased, and therefore let's deal with this issue at that particular point. That's my understanding of his argument.
Yeah. No, that of course is true, Justice Mulahleli. If what he's complaining about is that at that point we should have moved an application for recusal, well then kill me. We didn't move the application for recusal. But the point I'm making is that having not made that application, despite whatever the client wanted to do, the point of the matter is that when whatever assurance, and I don't want to get into the consultations now, but whatever assurance we might have given him, when the judgment comes, he says, aha, you see, I told you so, Mr. Mpofu. Look, they won't even accept condonation, let alone I told you that these people have made up their mind. That's where the actual bias. So from the point of view of the client, that's what happened. I accept, Justice Mulahleli, that another option you could say, well, if you want to shoot me for not doing the recusal at that time, well, we didn't. That I accept. But that does not answer the question of a reasonable perception of bias on the part of the litigant, not me.
Okay, thank you.
So yes, and then the issue, I still haven't found this case, but the one of the cases in our heads says that makes the point that I made, which is that this is something that is, it might look rough now, but it actually is something that will lead probably to the absolution, not just of the judges, but of the court, the administration of justice in general. Because when another court hopefully finds that the perception might be reasonable, but there was no actual bias, then that alone would vindicate the status of our courts. Because we live in South Africa, so let's not be naive. There is a perception that cases that involve Mr. Ramaphosa will always be found in his favor. And I suppose that happens to all powerful persons, probably in other countries as well. So that perception needs to be put to bed. All that Mr. Magashule is doing is to make sure that he doesn't go around in dark corners accusing the court of bias, but not have the courage of his convictions to bring it here up front. And that's what he's doing, and we're doing it unflinchingly to ensure that that matter is put to bed one way or the other.
Mr. Mpofu.
Am I in that time of the world now? Okay, yeah. Just five minutes then. The one point I want to make is Mr. My Nature also creatively introduces. We accuse the NEC of re-engineering the conference resolution, but Mr. My Nature is guilty of the same thing. I think he belongs in the NEC because he says that those who corruptly use money to influence conference outcomes. No such thing in the resolution. You'll find it at 003-775. It says, including those who use money to influence conference outcomes. Doesn't say anything about corruptly. The mere use of money. Remember, the Integrity Commission resisted this. Mr. Ramaphosa wanted to say, no, we must have a rule that accommodates this because it's the new modern world, and the Integrity Commission said, no, the use of money must be prohibited, whether it's good or bad or indifferent. And that's what conference wanted. And all I was saying that Mr. Ramaphosa, I'm not accusing or insulting as Mr. Trengov tries to say. It's not me. If Mr. Ramaphosa feels insulted, then he insulted himself. Because he said in front of Judge Zondo that he was aware of corruption for 4 years and he did nothing. That is a crime under Section 34 of the Corruption Act. It's a crime. So if, number two, he says to the court in the High Court that he himself paid money from his pocket to influence the outcome of the conference. He said it, not me. So that all was saying that conduct, both the one before the Zondo Commission and the one that he confessed to under oath to the court, falls foul of this resolution of the use of money to influence conference outcomes. That's all. And if it does, then he must step aside. If he must step aside, then he was suspended lawfully. That's it. So, but anyway, like I say, I don't need to convince this court about that. All we're saying is that, and what is more, is that then the judgment that he attached at 003-580 is completely irrelevant, and therefore it should have been struck out. So it's just a dominoes effect of reasonable prospects coming from every corner about issues that another court would find might reasonably find differently on. I won't go because of time. I don't want to fall foul now of Justice Colopen's grace here. So I won't go to the sections 17(1)(a)(2) issues to round up, but I think I dealt with those in chief.
Yes.
I'm indebted to the court. As the court, please.
Thank you very much, Mr. Mpofu. That concludes the arguments on the application for leave to appeal. Thank you to both teams for assisting the court, both with your heads of argument as well as your written submissions, and also in keeping within the 3-hour time that we designated. We set down the application for leave to appeal as quickly as we could, mindful that these are matters that are inherently urgent, and we will apply the same discipline to the judgment that we are required to write. You'll be informed in the ordinary course as soon as the judgment is ready. It will be uploaded onto case lines, and a notification will be given via our registrars with regard to when the judgment will be uploaded onto case lines, but it will be soon. Okay. Thank you.
Thank you, my lord. I did intend to start by thanking the court and we're indebted to the court for setting this matter down as urgently as it did, and knowing that you yourself are in urgent court, Justice Kalapan. We appreciate that because the matter is generally urgent.
Okay. Well, it's just not myself. My other two colleagues are also. We all work in two busy divisions. But thank you both of you. And with that, judgment is reserved and the court will adjourn. Thank you.
Let's call, please.
Adios.